Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about legal insurance policies. Cases that should have gone to the Supreme Court of Canada, but didn't. Vladimir Grabovsky purchased a legal insurance fund. This is essentially a fund that covers you in case you get sued or in case you encounter an issue that needs a lawyer. They'll pay your legal fees for you. He purchased it while he was a student at university, and in the course of his dealings with the university, something happened that caused him to want to sue the university. When he filed the lawsuit against the university, he asked for the legal insurance fund to pay him the costs associated with this litigation, to appoint him a lawyer and pay for the legal fees, and to pay the costs associated with his application being struck as an abusive process. The insurance fund denied his claim. And the court had to consider whether or not it was appropriate for the insurance fund to deny his claim, and also whether or not sanctions should be imposed against him as a result of his vexatious and frivolous conduct in filing the lawsuit. This case went all the way to a leave application at the Supreme Court of Canada, and it raised an important issue, which is whether sanctions can be imposed for vexatious litigants, people who file claims that are clearly an abusive process, and claims that have no merit whatsoever and are brought like freemen of the land claims. It was another instance in which the Supreme Court of Canada could have done more to deal with the problem of litigation that's being advanced by people who don't have any reasonable cause of action and who are doing it to abuse the court system, to harass other people, and to drag other people into protracted proceedings that will never be successful and have no merit in fact or law. As far as I'm concerned, the Supreme Court of Canada should be interested in stopping these people and putting up more hurdles for them from initiating this litigation in the first place. This type of litigation can cost the defendants thousands, if not hundreds of thousands of dollars when dealing with particularly vexatious or frivolous litigants who file a lot of claims against them. And so should courts not have the power to impose sanctions beyond just saying the registry won't accept your filings anymore, or you have to apply for an order before you can initiate a proceeding in the court? That's not really a sanction, that's just a hurdle. And these people work to overcome those hurdles. A sanction punishes them for using the court system to abuse other people and for abusing the court system that we have. Ultimately, this would save millions of dollars every year in unnecessary litigation, court time, unnecessary filing, and unnecessary legal fees for numerous defendants who are having to defend themselves against these completely bogus claims. To me, the Supreme Court of Canada missed an opportunity to do something that opened the door to preventing this type of behavior from litigants and to making the justice system more fair for people who find themselves on the other end of a lawsuit. It's unfortunate that the Supreme Court of Canada didn't take the opportunity to recognize this issue and to recognize the importance that it has to court registries all across the country. Hopefully next time the Supreme Court of Canada will deal with this issue and will have something that will actually prevent people from filing vexatious and frivolous claims in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.